ordered a pre-sentence investigation, which was completed in this case. The court this time will proceed to sentence. Prior to that, I will hear from both the state of Ohio and the defendant. Prosecutors, stand.
May this, these brief remarks please the court. They will be very brief, and then I will turn the rest of our remarks over to my co-counsel, Ms. Schiffel. This has been a long and arduous process. The Attorney General has asked me to state in open court. From his standpoint, this has not been political, vindictive, based on anger or retaliation. I believe that BCI and their agents have done a commendable job. I thank my co-counsel. I was assigned this case in October of 2012, and it's taken a long, long journey. We also want to thank the court for its integrity, its skill, its hard work, its common sense. I've been a lawyer a long time, as have you, Judge. And you have conducted this trial, in our opinion, with total integrity and professionalism. We appreciate it. So we'll let it go at that. I'm not going to try to blow smoke out here. And I want to thank defense counsel, too. Because in my opinion, defense counsel has been an honorable lawyer who's done a good job for his client. And I appreciate his respect and the way he has treated us. And I hope he feels the same way about us. With those remarks, Your Honor, I will let Ms. Schiffel deliver the true substance of what we have to say, which will be brief. Thank you for your time.
Thank you, Your Honor. As you're aware, yesterday the state filed a sentencing memorandum. And because of that sentencing memorandum, we've obviously laid out all of our arguments to the court as to why we feel these sentencing factors support a sentence involving substantial incarceration, as well as a substantial amount of time hanging over the defendant's head. Since filing that sentencing memorandum, Your Honor, the state has had the opportunity to review the pre-sentence investigation report. The state vehemently disagrees with the pre-sentence investigation report, as it has ignored several factors involving the seriousness of the defendant's conduct and his likely recidivism. Specifically, it ignored the factor that the defendant caused serious economic harm to Athens County, that the relationship with Athens County as the sheriff facilitated his offense, that he has been convicted of organized criminal activity by the jury when they found him guilty of engaging in a pattern of corrupt activity, and ignored his self-reported previous conviction. Your Honor, we've also reviewed the letters submitted by the defendant in support of him. The letters and the PSI ignore the fact that he has been convicted now by the jury of perjury. Perjury is perhaps one of the most serious offenses in the state's opinion, because it shows that he has been convicted of lying to this honorable court. And Your Honor, that conviction cannot be taken lightly, as it has been ignored by people who have supported the defendant and in the PSI. Your Honor, as we indicated in our sentencing memorandum, and the PSI does agree to this, the defendant has shown no genuine remorse. In his PSI, if you recall, his statement was that it is simply a political conspiracy again between Keller Blackburn and him. He made that very argument on the stand, Your Honor. The jury had the opportunity to listen to it, and by finding him by convicting him of 18 counts, they clearly did not believe his story. He shows no genuine remorse for his actions. And then, Your Honor, further, he says he hasn't done anything that sheriffs for the past 20 years haven't done. If you recall from the testimony, no sheriff came in on behalf of the defendant and said he did it just like that Pat Kelly did. In fact, the state produced 2 reputable sheriffs and their testimony that said, no, that's not how we do it, including a representative from the Buckeye State Sheriff's Association. Finally, Your Honor, we ask that you order the state's miscellaneous requests and of one specific thing that is of importance. Shortly after the trial, the state reached out to defense counsel and asked for the defendant to resign, asked for him to return property belonging to the Athens County Sheriff's Office, asked him to further give any passwords to social media sites to the Athens County Sheriff's Office. The defendant continues not to cooperate or produce those items. Your Honor, again, he's shown no genuine remorse. He continues to thumb Athens County and forcing them into a resignation lawsuit. He continues to show no genuine remorse by not turning over his badge, his gun, or any passwords so that this community can move on. Your Honor, the defendant has shown no genuine remorse, and for all of the reasons outlined in our sentencing memorandum, we implore you to sentence the defendant to a substantial amount of time of incarceration, as well as a substantial amount of years hanging over his head. Thank you, Your Honor.
Thank you, Your Honor. Your Honor, this court is certainly familiar with the purposes and principles of felony sentencing and the statutory framework that goes along with that, so I will not address that with the court. I know it is tempting, as the state has suggested, to make an example of Pat Kelly and to send him to prison for a significant period of time, because that's what they're asking for. But, Your Honor, I would submit that sentencing is about the individual. The individual is the person who is being sentenced. And if you consider Pat Kelly as a man, you will see that he has no prior record other than a minor misdemeanor that was sealed. You will find that he is a good family man, a good husband, a good father. You'll find that he's a man who served our country in the military, in the U.S. Marine Corps, received an honorable discharge. You'll see a man who served over 20 years in law enforcement, a man who went overseas to combat areas to teach others how to police and engage in law enforcement. You will see a man who was a very effective sheriff, a man who tackled a very difficult drug problem head-on, curbed that drug problem, stopped crimes, and he did that for Athens County. If you consider his lifetime record, if you consider his lifetime achievement, and if you consider the PSI, which also points out those things and recommends community control, we would ask the court to consider placing him on community control. The state submits that he caused substantial or serious financial harm to Athens County, and yet the total amount of restitution after years of investigation, countless man hours, the amount of restitution is less than $6,800. With regard to the special requests made by the state, some of those requests are simply not permitted by law. The state is asking the court to impose sentences that the court just cannot do. There are other statutory frameworks to remove him from office. There are other statutory frameworks to recover his salary. It's something that the court just can't do under the sentencing laws as they currently exist in the state of Ohio. Further, the state has made an issue that he has not turned over his property or passcodes. As the court is well aware, my client has been incarcerated since the moment that the jury returned the verdict. He has not had the opportunity to do that. He will certainly return any property to Athens County that belongs to Athens County and will cooperate fully in that regard. Your Honor, we have submitted to the court a number of letters from the individuals who support Sheriff Kelly. He has a tremendous amount of support here today in this courtroom and outside this courtroom. We're simply asking the court to consider that support. Finally, Your Honor, my client would like to make a statement to the court.
Do you want to address the issue of pension benefits and the state's portion of their brief that deals with that issue?
Yes, Your Honor. I think the state is partially accurate in what they're requesting. They are requesting, with regard to his retirement, his PERS, the way the statute, as I read it, states, my client is entitled to receive his contributions and any earnings from those contributions. Any employer contributions to his retirement would be forfeited back to the state. Of my client's contributions and interest of that can be used to pay restitution only, which we would certainly agree the court can do that in the amount of just roughly $6,800. The balance then should be returned to him. The state is asking that also be used to pay his past salary, fines, and court costs. There's no statutory authority for that. Thank you, Your Honor.
Just looking down that restitution summary, maybe?
I do, Your Honor. May I approach?
Oh, actually, I found my copy. All right, Mr. Kelly, the court will hear from you. Is there anything you want to say prior to the imposition of sentences in this case?
Thank you, Your Honor, there is. And I wrote it down, so I'll read it from you. As I've sat in isolation at the regional jail over the past 6 weeks, I've had a lot of time to reflect on the past events surrounding this trial. I was elected twice, overwhelmingly, to represent the people of Athens County as their sheriff. I was able to unite a county, and together we accomplished great things. We touched the lives of many people in a positive way, and we restored a broken sheriff's office to become the leading agency, law enforcement agency in our county. During Prosecutor Schifffel's closing remarks, she stated that the truth never changes. I pray that someday in our courtrooms that it will be about just truth and justice. How will we ever discover the truth when under our current system, valuable testimony and evidence is continually suppressed? 2.5 years ago, County Prosecutor Keller Blackburn requested an investigation be opened on me. My life and the lives of my family and friends were placed under a microscope, subject to investigation after investigation. Shortly thereafter, the investigations began. Susan Gwynn, a local attorney who is a friend of mine, approached me with an offer, a deal. If I would resign and walk away quietly, then all the investigations would go away. I took my stance then, and my position has not changed. When people of power use their political positions to destroy others for their own personal and political gains, no one prospers. The system is only weakened. Many people's lives have been affected by my decisions and my circumstances, and it's cost some of them their jobs. The court instructed the jury that a person is innocent until proven guilty. In reality, that's not true. Innocence until proven guilty is just an adapted concept to convince and reassure ourselves and our society that we are morally fair to the accused. I say innocent until proven guilty is not because there's a human expectation that everyone that stands accused of a crime is guilty regardless of the accused status or who they are. It's only human to have a preconceived notion that an accused person must have done something wrong. But that just does not make it true. I would not have risked my life's work and our future by standing firm and fighting for what was right and true. And I am the only one that knew the truth. Person after person testified to the truth on my behalf. They were employees that worked side by side with me. Individual current office holders testified before this court. They followed the same practices that I have been found guilty of. My former campaign chairman, Clinton Stanley, testified that he knowingly accepted money illegally. By their own words, they've condemned themselves. To quote Assistant Attorney General Bill Skank, this was a very complicated case, and I agree. This was a paper case, or lack thereof, of documentation. The prosecution did not prove guilt. It just convinced a jury to believe that I was guilty. I do not blame the jury. They had a difficult position. Injustices happen every day. In closing, I do disagree with this young lady's assessment of the truth. The truth does change, and the truth is on my side. I am blessed by a wonderful God that I serve, a wonderful and loving family, and the best friends and supporters that anyone could ask for. And I believe too, Your Honor, that you did a very remarkable job. You were very fair, and it was a difficult time. I want to thank you, Your Honor, for allowing me this time to address the court.
Your Honor, yes, Your Honor, just briefly. First of all, I appreciate the compliment from defense counsel about being a young lady. Thank you, I don't need it though. Second of all, Your Honor, the defendant has proclaimed that the state made him an offer to resign prior to any of this investigation going on. This occurred prior to me ever being, I think, at the Attorney General's or assigned to the case, but Prosecutor Roberts has been on this matter since the beginning, and no such offer was ever made. That again is another lie that the defendant wants the community and this court to believe. His employees testified about the truth. You listen to the employees. What employees testified about the charges and the time frame of the indictment? The witnesses put on the stand on behalf of the defendant were not relevant. Your Honor, we ask that you follow the state's sentencing recommendation. Thank you.
All right, thank you. The court reviewed the pre-sentence investigation. I have read the letters of support on behalf of Sheriff Kelly. The court also presided over the 2-week trial in this case. The defendant was convicted of multiple counts of theft in office and other theft offenses by a jury. Prior to that, he was indicted by a jury in criminal offenses. The jury took really looked at this case at length and depth. They were out at least 2 days or more, and they acquitted Mr. Kelly of many of the charges in the indictment. Now, whatever sentence the court hands out in this case, one side is not going to be happy, but that's not our justice system. Our justice system is the court does what it thinks is the fair thing to do. I've considered the purposes and principles of sentencing in this case, and quite frankly, to not sentence the defendant to prison would demean the seriousness of the offense and not adequately protect society from future criminal conduct by yourself and others. The defendant was convicted of a variety of offenses, including stealing from the county of Athens, selling property that didn't belong to him, belonged to the county of Athens, to a scrapyard, using county monies out of either an FOJ fund or a law enforcement trust fund to pay for items of clothing, of meals. Everybody else had documentation when they took money out of the cash box to pay confidential informants, except Sheriff Kelly. Didn't have any receipts, and the informants were dead, so nobody could check. No receipts whatsoever. The circumstantial evidence in this case was overwhelming of guilt, and the court does believe that all along Mr. Kelly has seen himself as a victim rather than looking at himself and his conduct and what he has done for this community. Not just his family, but this community. You've torn this community apart by your conduct and your arrogance and your refusal to accept responsibility. The first issue the court's going to determine is the issue of merger. Court's going to follow State versus Johnson, 128 Ohio State 3rd, 153. When determining whether or not two offenses or allied offenses are similar import subject to merger under revised code section 294125, the conduct of the accused must be considered. 294125A provides where the conduct of the defendant can be construed as two or more allied offenses of similar import. The indictment can contain counts for all offenses. The defendant may only be convicted of one. Subsection B of that statute provides the defendant's conduct where it constitutes two or more offenses of dissimilar import, or where the conduct results in two or more offenses of the same or similar kind, but committed separately or with a separate animus as to each. The indictment may contain counts for all offenses, and the defendant may be convicted of all of them. The court has applied this analysis to the indictment in this case regarding the various counts in the indictment that he was convicted of. The court has considered whether or not, under State versus Johnson, it's possible to commit one offense and commit the other with the same conduct. And then I looked further, if the multiple offenses can be committed by the same conduct, whether or not they were a single act with a single state of mind, whether they were committed separately or with a separate animus. Now, I've indicated that the courts consider the purposes and principles of sentencing under revised code section 292911 and the seriousness and recidivism factors in 292912. Obviously, the purposes and principle of sentencing is multifaceted to protect society from future crime by the offender and others, to punish the offender by using certain standards, minimum standards where possible, consider the need to incapacitate the offender, and deter other offenders from committing the same crime. And the sentence must be commensurate and not demeaning to the seriousness of the offense and consistent with other sentences. Reviewing all of the information, and after sitting 3 weeks in trial in this case, the court finds the seriousness and recidivism factors in this case under 292912 are as follows. The court does find that the victims in this case, the Athens County, which is a seriously, which in terms of economic harm, $6,000 may not seem a lot to the defense in the scheme of things, but $6,000 to Athens County that is financially strapped is a lot of money. You only have to look around the courtroom to see that the furniture hasn't been replaced. The sheriff testified at trial that there wasn't money for cruisers. This county needs every dime that it needs, and the taxpayers are entitled to see that that money is spent appropriately. Under subsection 3 of 292912, the offender held public office, and all of these offenses, most of them are related to that office. The offenders, under section 5, the offender's elected office was used to facilitate the offense and likely to influence the conduct of others. Having considered these purposes and principles of sentencing, the court hands down the following sentence. In counts 1 through 7 of the indictment, these are all felonies of the 5th degree. There is no merger on these offenses. It is not possible to commit all these offenses with the same conduct as they were committed on separate dates and with different animus. Count 8 and count 28, which are theft and theft in office, merged as a matter of law. The court is going to merge count 23. This involves the theft of property from the keys. I'm going to merge count 28 into count 8, which is theft in office. In reference reference to counts 1 through 8, the court is going to impose a 1-year prison sentence. I'm going to order those sentences run concurrently with one another. In reference to the restitution figures that are due and owing to Athens County, the court's going to order the defendant in reference to count 1, repay the County of Athens $457.30. Count 2, $284. Count 3, $113.30. Count 4, $214.40. Count 5, $404.80. Count 6, $945. Count 7, $437.25. And count 8, $80.55. In reference to count 18, which is failure to keep a cash box, which is an unclassified felony, the court's going to sentence the defendant to 6 months in the Athens County Jail concurrent with counts 1 through 8. Count 11 and 24 merge under State versus Johnson. The court merges count 24 into count 11, therefore I will only sentence on count 11, theft in office. This is for the improper use of campaign funds while running for sheriff. There's evidence at trial, fundraisers were used. That money never made it into the campaign account. The incident involving Clinton Kelly, which was scratched out according to the testimony, and that money was instead of being placed in his campaign fund, was put in his personal checking account, and that came out at trial. In reference to the count would be count 11, involved the improper use of campaign funds for the period of January 22nd, 2008 through December 16th, 2008. Counts 12 and 13 also are thefts in office. These also arise from the campaign conduct August 23rd, 2008, for not turning in the money for the fundraiser. The court is going to sentence the defendant on counts 11, 12, and 13 to 1 year in prison. I'm going to order that sentence run consecutively with the 1-year sentences in counts 1 through 8. In count 16, perjury. This is for lying to the court as to whether or not you had any records at all documenting dealing with confidential informants. The tape was played under oath. You said no. In the court's opinion, this is not the first time you've disobeyed, well, it isn't the first time you've disobeyed the court order. I held you in contempt in the discovery phase because you didn't turn over everything. Then I allowed you to purge yourself of that contempt when you finally, months later, late gave the information discovery to the state. And then I put you under oath, and I asked you whether or not that was all the information you had, and you swore, you raised your hand, you said, yes, that's all the information I have. Lo and behold, a search of your home computer found additional information that you never turned over that was on your personal computer to the state. Then we get to the, I'm digressing here, but the trial, then I held you in contempt of court again because you couldn't follow my order not to talk to the press. And this is all on the record. We have a sidebar conference. I have the reporter at sidebar. The reporter said, yeah, the sheriff talked to me during the break about the case. I asked the sheriff, did you talk to the press about the case? I can't remember. I said, that was 3 minutes ago. So in the court's opinion, you continue to deny, and lie, and lie, and lie. In reference to the perjury count, felony of the 3rd degree for lying to the court under oath, the court is going to sentence you to a 2-year prison sentence on that count. That 2-year prison sentence is to run consecutively with the 2-year prison sentence already handed out. Now the court turns to engaging in a pattern I'm going over, I'm not mentioning the ones that the defendant was acquitted of, obviously. Count 25, engaging in a pattern of corrupt activity. Under State versus Miranda, 138 Ohio State 3rd, 184, the Ohio Supreme Court held that it is unnecessary to do a State Johnson analysis of merger when dealing with a RICO statute because the underlying predicate offenses do not merge as a matter of law. Before the court turns to that issue, I do want to also indicate the restitution regarding the campaign amounts are several, are over $2,000. However, that campaign fund, well, is it defunct?
It is.
All right, that campaign fund is defunct, therefore the court's not going to order restitution since it is a non-existing account. There's nobody to pay the money back to. Getting back to engaging in a pattern of corrupt activity, I will indicate that the pattern of corrupt activity stemmed from 2008 to 2013. It started when Sheriff Kelly was a candidate, misusing campaign funds. Both times he ran. It continued on in office when he sold property belonging to Athens County without their permission, pocketed the money, went out, used money that could be used to purchase cruisers or other valuable items that the sheriff's office needed for meals, took money out of the cash box. This conduct was not a one-time thing, but over a period of time, 2008 to 2013. The defendant used the criminal enterprise, first of his campaign committee, and then through the office of sheriff, to funnel money to him for his personal use. In reference to the RICO count, the court has tried to look at other cases where similar things occurred. You can't find a similar case when you deal with public officials because everyone is specific. In the State versus Miranda decision that indicated that engaging in a pattern of corrupt activity and the predicate offenses don't merge, that person got a 6-year prison sentence consecutive to an 8-year prison sentence. However, you have to look at those facts. That was a drug cartel out of Mexico, and therefore a 6-year sentence in reference to that charge was appropriate. The court, in reference to the charge of RICO engaging in a pattern of a corrupt activity, the court's going to impose a 3-year prison sentence. I'm going to order that sentence run consecutively with the sentence already handed out. The court's going to impose 5 years of mandatory post-release control on this count. All other counts previously handed out, the court is going to impose a post-release control sentence of discretionary of up to 3 years on each of those 3 counts. The court will give you credit for time spent in the Athens County Jail or in jail towards that sentence. The court also at this time orders Sheriff Kelly to return any keys, passwords, any property belonging to the city of County of Athens. Within 24 hours, you can use your family or your attorneys to turn over that. The court's also going to order, and I agree with defense counsel, that the only portion of the PRS that can be attached, first of all, is if you have put in money in a deferred comp or any other type of program, that would be considered an IRA. However, the court is going to order that any monies that you get paid from TERS, that money be used to repay the county of repay repay the county of Athens for the theft offenses. The portion paid by the state to the PERS will go back to the state. However, the court's going to order that all restitution owed to the city of Athens come out of those monies from your pension that should go to the taxpayers of Athens County for the loss they've suffered as a result of your conduct. The court also again finds absolutely not one shred of remorse on your part for any of this conduct from 2008 to 2013. I'd like to see the attorneys at sidebar.
His son there behind him? Yeah. Okay. Sorry, I'm all over yours.
28, count 8 merges with 21, and all other aspects that remains in full force and effect. Attorney Wood, I want to check with you on the record whether or not you intend on filing a notice of appeal in this case, or is Mr. Kelly requesting counsel?
Your Honor, I have discussed that with my client. We do intend to appeal the jury verdict in this case. At this point, he has decided to retain counsel, whether it's me or someone else. So we are not asking for court-appointed counsel for the appeal. We would ask the court to consider a stay of sentence pending appeal, and to order whatever bond the court deems appropriate, including house arrest, electronic monitoring, whatever the court deems appropriate.
The court will instruct you with whether or not you remain on the case or not, either way that you file a notice of appeal within 30 days.
Yes, Your Honor.
Lastly, the court has already referenced its reason for consecutive sentences under 292914. But I'm going to restate it again. The court finds that consecutive sentences are necessary to protect the public from future crime and punish the offender, and consecutive sentences are not proportionate to and the danger posed to the public, and at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm committed by these offenses was so great that no single term for the offenses committed as part of the course of conduct adequately reflects the seriousness of the offender's conduct. Again, that goes to the various types of theft and over a long period of time. That concludes the proceedings. I'll prepare the entry. Court adjournment.
All rise.